This is your government video for the Fourth Amendment, search and seizure. So here is a copy of the Fourth Amendment. Go ahead and take a moment to read this. So the Fourth Amendment's got a lot of parts in it. It's got a lot of individual liberties, particularly if you are being accused of something by the government. So if police officers or a federal prosecutor believe that you've committed a crime, but you have not been deemed guilty of that crime in a court of law, then you have a lot of rights. The Fourth Amendment, we talked about a little bit in Miranda versus Arizona, and this is the case that said that the police officers have to make you aware of your rights. The police officers and lawyers who work for the government, they deal with the law all the time, and they are experts in what the law is. You might not be. So they cannot use their information about the law against you. And in Miranda, in the decision in Miranda, they said that when being arrested, you have to make people aware of their rights. So you have the right to remain silent. You have a right to an attorney. If you do say something, it can be used in court against you. Now, requiring that police officers make us aware of our rights enhances your individual liberty and makes it more difficult for the government to try to coerce us to tell them information that could be harmful to us in a case. So Miranda versus Arizona was a big win for individual liberty and for people who are accused of crimes. But some people would also argue that it reduces public safety because people can get off on technicalities now. There are, of course, situations in which there are exceptions to rules. So there are times in which an interrogation or somebody who confesses before they were told about their rights, sometimes those things are allowed into court, but it would have to be an exception situation. It's not typically in a normal case, the police officers would have to make you aware of your rights. In fact, most of them not only tell you, they make you sign a piece of paper to that effect. We also talked about Mapp versus Ohio. This is the case where the police officers thought the woman was harboring evidence in committing a crime, and they came to search her property. They told her she had a warrant, but it really wasn't. It was a blank piece of paper. And so, violating her rights, they did find some evidence in this search, but because it was an illegal search and they did not have a warrant, they can't use that against her in a court of law. This is called the exclusionary rule. So we want to encourage that police officers follow the law when they're collecting evidence against you. And if they don't follow the law, if they break into your house and take evidence without a warrant, if they don't read you your rights, if they do some other things that are considered illegal, then they can't use that information in the courts. And if they can't use it against you to try to prove you guilty, then there's no incentive for them to try to break the law to prove that you're guilty. So we don't want the government to violate your civil liberties if they believe that you committed a crime. Now, we've also selectively incorporated this amendment through the 14th Amendment, so it now also applies to state laws. So basic issues of search and seizure. The amendment says that the police officers have to have a warrant, and that warrant has to be based on probable cause. The police officers don't get to decide what that is. A judge does. So the police officers tell the judge what evidence they have that makes them think you probably did the crime. The judge will either sign the warrant or they won't. If they do sign the warrant, then they can go and use that warrant to legally search your property and collect evidence that will be used against you. They don't always need warrants, however. There's a couple of exceptions. When you're in your automobile, if you are in a vehicle, that vehicle can be driven away. It can be used to drive through an officer, to hit people. So you have generally less rights when you're in a car versus when you're in your home. So when you're in your automobile, they don't need probable cause. They just need reasonable suspicion. So they just need to think you're suspicious to search your property as opposed to you probably committed this crime. And this leads us to what Terry stops are. A Terry stop means that if you're in a vehicle and you are believed to be armed or dangerous, or they have any reasonable suspicion, they can not only stop you, they can pull you out of your car, frisk you, and cuff you, and then search your car. They would have to prove that their belief that you were armed and dangerous. They would have to prove that in court. So, what gave them the belief that you were armed and dangerous? This, of course, is very controversial today. There's lots of evidence that people of color are pulled over to do Terry stops far more than white men and women. And although you're not allowed to use race to determine whether somebody is suspicious or not, a lot of times our ingrained, um, not just ingrained racism, but just ingrained um, beliefs that we've had and things that have happened throughout our life have been ingrained in the training process and throughout society. And that could be leading to why non-whites are pulled over at much higher rates than white auto drivers. So the police can stop and frisk you without charging you with a crime. They also do not need a warrant if they're lawfully arresting you for a different crime. So if a police officer pulls you over to lawfully arrest you for drugs, and they search your car or they search your home with a warrant legally, and they find evidence that you committed some other crime, then they can also use that evidence for the secondary charge. If you give the police consent, they don't need a warrant. So if the police come to your home and ask to come in or ask to search, they don't need a warrant anymore because you've given permission. And anything in plain view does not need a warrant. So if they see you rob a bank and then you run into your home and shut the door, they don't need to wait for a warrant. If they see you commit a crime and they're chasing you, they can continue forward. And of course, if you're committing a crime in plain view in public with your windows open, things like that, then they don't need a warrant. And anytime that they believe that lives or property are in danger. So if they hear somebody screaming, and they believe that somebody is being physically harmed, they can, of course, break in and help that person without a warrant. They don't have to wait for a warrant. There is also an exception for schools. So all government schools, public and charter schools, can randomly drug test students. This particularly happens for students who are involved in sports and activities. But they can randomly drug test students or search backpacks and things like that for drug use on campus.